You have the floor, sir.
Mr. President, Madam Vice President, distinguished members of the Court, good afternoon. It is a great honor and privilege to appear before you. I have been asked by Myanmar to set out its position on the burden and standard of proof. I'm afraid I will not be doing Charles Dickens nor James Joyce. I probably could do Goethe or Schiller, but as this is a court of law, I will focus on the legal issues before you. Let me start with the question of the burden of proof. I can be brief here. The parties agree on the principle that a party alleging a fact bears the burden of proof. While the court has held that this principle is not an absolute one, it has consistently applied the principle in cases of alleged genocide. In such cases, neither the subject matter nor the nature of the dispute makes it appropriate to contemplate a reversal of the burden of proof. The mere fact that the alleged facts occurred in the territory not under the control of a state also does not shift the burden of proof. In the Croatia case, the court expressly stated that it was not for the respondent to prove a negative fact. For example, the absence of facts constituting the actus reus of genocide. The same, of course, applies to the absence of facts establishing the mens rea, and in particular, genocidal intent. The burden is thus squarely on the Gambia to demonstrate the existence of the facts put forward in support of its allegations of genocide. It is not for Myanmar to provide explanations of the facts alleged by the Gambia. Yet, as Professor Meron has just shown, the Gambia's methodology leads in practice to a reversal of the burden of proof, since the so-called indicators of genocide seek to create a presumption of genocidal intent. Mr. President, members of the Court, let me move on to the standard of proof. Again, there is general agreement between the parties on the applicable standard. As the Court held in the Bosnia and Croatia cases, a finding of genocide requires evidence that is fully conclusive. The Court must be fully convinced that it has been clearly established that the crime of genocide or the other acts enumerated in Article 3 of the Genocide Convention have been committed. This is a heightened standard of proof, which is reserved for charges of exceptional gravity. As the Court noted most recently in Ukraine versus Russia, charges of exceptional gravity, such as the crime of genocide, require proof at a high level of certainty. The parties disagree over what is meant by the standard of conclusive evidence and what degree of certainty the evidence must provide. Myanmar submits that fully conclusive evidence must compel a certain conclusion. It must be more than just credible and persuasive evidence. It is evidence that must not be contradicted by other evidence and it must establish a fact beyond reasonable doubt. The fully conclusive evidence standard is in fact equivalent to the beyond reasonable doubt standard of proof applied by international criminal courts and tribunals. This is also the view widely held in the literature. But more importantly, Myanmar's submission is supported by the court's case law. When the court adopted the conclusive evidence standard in the Bosnia and Croatia cases, it made clear that it applied the same conclusive evidence standard as in the Corfu Channel case. In that case, the court held that, I quote, "Proof may be drawn from inferences of fact, provided they leave no room for reasonable doubt," end of quote. When the judgment is read as a whole, it is apparent that the expressions conclusive evidence and no room for reasonable doubt were intended to have the same meaning. In the Bosnia case, the court found that one of the conditions for the responsibility for complicity in genocide was not fulfilled because some of the facts were not established beyond any doubt. Commenting on this finding, Judge Gaia wrote in his separate opinion in the Croatia case, I quote, "In substance, although different wording was used, the court applied the same standard of beyond all reasonable doubt that the ICTY and the ICTR apply with regard to individual crimes." End of quote. That the standard of proof applied by the court in genocide cases is comparable to the beyond reasonable doubt standard was also confirmed by the court's president in a presentation of the court's jurisprudence to the Sixth Committee of the UN General Assembly in November 2007. After referring to the standard of fully conclusive evidence in the court's Bosnia case, President Higgins stated, I quote, "There have been some curious comments by observers as to this being a higher or lower standard than beyond reasonable doubt. It is simply a comparable standard, but employing terminology more appropriate to a civil international law case." End of quote. The Gambia, of course, says this is incorrect because the court is not an international criminal tribunal. The Gambia is mistaken. There is no distinction between a criminal standard of proof and a civil state responsibility standard of proof when it comes to allegations of state responsibility for violations of the Genocide Convention. While the terminology may be different, the substance of the standard is the same, as shown by the court's case law. If the fully convincing evidence standard were indeed a different standard, the Gambia would need to define that standard, something it has not done, either in its written or in its oral pleadings. The heightened standard of fully conclusive evidence, or evidence beyond reasonable doubt, can be met either by direct evidence, which directly proves a fact, or by indirect circumstantial evidence. Circumstantial evidence consists of facts from which a relevant fact can be inferred. The basis of such inference must itself be facts established by fully conclusive evidence. Mr. President, members of the Court, this brings me to one of the decisive questions in the present case. The proof by fully conclusive evidence of the intent to destroy, in whole or in part, a protected group, the genocidal intent or dolus specialis. According to the Gambia, documents that reference the intention to destroy a group in whole or in part may be considered direct evidence of genocidal intent. The Gambia has not provided any direct evidence, despite a claim to the contrary in its reply. In the present case, genocidal intent can thus only be established by circumstantial evidence. The Court has recognized that a state that is not in a position to provide direct proof of certain facts should be allowed a more liberal recourse to inferences of fact and circumstantial evidence. A more liberal recourse to circumstantial evidence does not, however, entail any lowering of the standard of proof. In the Bosnia and Croatia cases, the Court, despite being faced with circumstantial evidence, required fully conclusive evidence in order to prove that the crime of genocide or the other acts enumerated in Article 3 of the Genocide Convention were committed. The same standard was also applied to prove attribution of such facts. Mr. President, members of the Court, this raises the question of how genocidal intent can be proven by circumstantial evidence. This is a question on which Myanmar and the Gambia fundamentally disagree. While Myanmar follows the Court's approach in the Bosnia and Croatia cases, the Gambia, following in the footsteps of the FFM, tries to establish a new indicators of genocidal intent approach. It is so set on establishing this new approach that it referred to it no more than 25 times in its presentations on the first day alone. The Gambia even suggested that the Court itself indicated in the Croatia judgment some of the most important indicators. However, there is no mention of indicators of genocidal intent in either the Croatia or the Bosnia judgment. Mr. President, let me compare the Gambia's indicators of genocidal intent approach with the Court's approach. On your screens, you can see a chart that depicts the Gambia's approach. It is essentially an inductive approach. Although, if you listen to the Gambia's presentation, it is more assertion than induction. The Gambia uses 7 so-called indicators which allegedly establish genocidal intent. It does not tell us why these 7 and not others. It also does not tell us how many of these indicators would have to be fulfilled for the court to find genocidal intent. But all this does not matter because, of course, all of exactly these very indicators are fulfilled in the present case. The Gambia also adopts a somewhat circular argument. It says the indicators, I quote, emerge from the evidence, only to then show that on exactly that very same evidence, these indicators are all fulfilled. In the course of the Gambia's presentation, the indicators mutate from strong to compelling, to powerful, and finally, to conclusive indicators of genocidal intent. What makes these indicators conclusive, either individually or collectively, the Gambia does not tell. Let me now show you a chart that depicts the court's approach in the Bosnia and Croatia cases. Unlike the Gambia, the court follows a deductive approach. Genocidal intent is proven by way of inference from a pattern of conduct. The court first examines whether genocidal acts and other atrocities committed during an attack on a protected group have been established by conclusive evidence. In a second step, the court then examines on the basis of 4 factors, which are listed in the box on the left, whether these acts form a pattern of conduct. That is to say, a consistent series of acts carried out over a specified period of time. It is in this context that the court in the Croatia case identified the 4 factors which the Gambia now claims to be indicators of genocidal intent. If at all, these factors indicate the existence of a pattern of conduct. They are not indicators of genocidal intent. It is only in a third and final step that the court examines whether genocidal intent can be inferred from the pattern of conduct. Thus, while the court found in the Croatia case that widespread similar attacks on localities with Croat populations amounted to a pattern of conduct, the court was unable to infer a genocidal intent from that conduct. Mr. President, this brings me to another important question. When can genocidal intent be inferred from a pattern of conduct? According to your own case law, the court is only fully convinced that genocidal intent has been established by inference if genocidal intent is the only inference that can reasonably be drawn from the acts in question. This has been referred to as the only reasonable inference standard. While the Gambia pays lip service to that standard, it does not apply it. Neither does it prove a pattern of conduct, nor does it establish that genocidal intent is the only reasonable inference from such pattern of conduct. All the Gambia does is assert that, I quote, "the only reasonable conclusion is that Myanmar acted in this case with genocidal intent," end of quote. Mr. President, members of the Court, it thereby relies on a conclusion by the FFM, conveniently overlooking that the FFM had concluded, I quote, "on reasonable grounds that the evidence supports an inference of genocidal intent," end of quote. An inference on reasonable grounds is not the same as the only reasonable inference. Furthermore, the reasonable ground to conclude standard is a standard of proof, which is applied by UN and other fact-finding missions. It is a much lower standard of proof than the fully conclusive evidence standard applicable in the present case. But this all is not the question. What is at issue here is not a standard of proof at all, but a standard for inference. The only reasonable inference standard refers to the degree of certainty that is required when drawing conclusions from circumstantial evidence. It ensures that the conclusions drawn by deductive reasoning are reliable and not based on speculation or unsupported assumptions. The graver the accusation, the higher the standard for inference. The standard for inference must also be distinguished from the standard of proof applicable in the present case. The standard of proof in genocide cases requires that the court must be fully convinced that there is genocidal intent. In order for the court to be fully convinced of genocidal intent, the standard for inference requires that genocidal intent must be the only reasonable inference from the circumstances. Mr. President, it is submitted that the only reasonable inference standard is a logical consequence of the fully conclusive evidence standard of proof that, in the words of President Higgins, is comparable to the beyond reasonable doubt standard of proof. If genocidal intent is not the only reasonable inference to be drawn from a pattern of conduct, there will inevitably be reasonable doubt as to the existence of genocidal intent. If, on the other hand, genocidal intent is the only reasonable inference, there cannot be any reasonable doubt about the existence of genocidal intent. Mr. President, it is not sufficient that genocidal intent is, I quote, "a manifestly reasonable inference," as stated by the Gambia's agent on Monday. It must be the only reasonable inference to be drawn from the established facts. However, the Gambia devoted a whole speech on Wednesday to demonstrate that genocidal intent was a reasonable inference. The only purpose of that speech was to muddle the waters and to misconstrue the applicable legal standard for inference. I can only invite the Court to reread the Gambia submissions at CR 2026/5, page 31, paragraph 28, and to compare it with paragraph 373 of your judgment in the Bosnia case, to see the whole fallacy of the Gambia's argument. It is also not sufficient to claim negatively that it is unreasonable to infer one specific other intent. However, again on Wednesday, the Gambia went to great lengths attempting to show that counter-terrorism was not a reasonable intention to infer from the facts. What the Gambia did not do was to demonstrate positively that genocidal intent is the only reasonable inference from the claimed pattern of conduct. For the Gambia, the world of inference is binary: counterterrorism or genocide, tertium non datur. But as I will show shortly, there are a number of other potential intentions that could be underlying the alleged conduct in the present case. If there is only one other reasonable alternative inference, then the inference of genocidal intent is not the only reasonable one, and therefore genocidal intent is not established to the required standard of proof. It has been said recently in the literature and otherwise that the only reasonable inference standard sets the bar unduly high and makes it virtually impossible to prove genocidal intent. This view overlooks that the only reasonable inference standard is a general standard for inferences from circumstantial evidence, whenever the heightened, fully conclusive, or beyond reasonable doubt standard of proof applies. And it is not limited or specific to the inference of genocidal intent. Any change to the standard for inference would thus have much wider repercussions. Mr. President, members of the Court, the only reasonable inference standard has not prevented international criminal tribunals from finding that genocide has been committed. The requirement that genocidal intent was the only inference that could reasonably be drawn from the acts in question also did not prevent this court from making the finding in the Bosnia case that genocide had been committed in Srebrenica. The claim that the only reasonable inference standard makes it virtually impossible to prove genocidal intent is in reality a cry of despair by those unable to prove genocide in the present case. The reason is not because the standard for inference is too high. The reason is because there is no evidence to prove genocidal intent. The Gambians and others therefore seek to move the goalposts. Mr. President, the Gambia argues that Myanmar seeks to generate confusion from the only reasonable inference language used by the court. However, it is the Gambia that creates confusion by mixing up the concepts of motive and intent and claiming that several motives may be underpinning a certain pattern of conduct. For example, it claims that the existence of, I quote, an ethnic cleansing motive does not preclude the existence of genocidal intent, end of quote. However, motive and intent are not the same, a point the Gambia accepts. While motives explain why a person is doing something, intent refers to the person's aim or objective. By an ingenious parlor trick, the Gambia simply declares all other intentions, including the intent to defeat terrorists, to be motives, so that the intent to destroy remains the only reasonable inference. But as the court found in the Bosnia and Croatia cases, ethnic cleansing, discrimination, and punishment fall under intent, not motive. And the same, of course, is true for the intent to defeat terrorists. Even if a pattern of conduct could be underpinned by two or more different intents at the same time, it would still be necessary to prove conclusively that genocidal intent was indeed one of them. On the screen, you can see several possible intentions on the right-hand side, including the intent to destroy, an intent to kill, an intent to cause bodily harm, an intent to punish, an intent to take revenge, an intent to discriminate, or an intent to displace. In order to conclusively prove the existence of the intent to destroy, the intent to destroy must be the only reasonable inference to be drawn from the pattern of conduct. If both an intent to destroy and another intent can reasonably be inferred from the pattern of conduct, then genocidal intent is not the only reasonable inference, and consequently, the standard of proof is not met. Mr. President, the Gambia further argues that Myanmar fails to establish the existence of any other reasonable inferences to be drawn from the alleged pattern of conduct, leaving genocidal intent as the only inference that was reasonable. This argument is based on a misunderstanding of the rules on the burden of proof. Myanmar does not have to prove other reasonable inferences that could be drawn from the alleged pattern of conduct. On the contrary, it is for the Gambia to establish that genocidal intent is the only reasonable inference, something it has not done. It is also not correct that there are no other reasonable intents that could be inferred in the present case. I have just shown you a whole list of other potential intentions. The Gambia itself mentions counterterrorism as a potential other intention. Counterinsurgency could be another intention, and so could be revenge and punishment. During the oral hearings on provisional measures, reference was also made to other reasonable inferences, such as ethnic cleansing. Myanmar submits that the information in the Gambia's written and oral pleadings provide ample alternative inferences to be drawn from the alleged conduct, other than genocidal intent. Let me conclude. The Gambia has the burden of proof to establish the existence of each and every fact that is required to establish the alleged breaches of the Genocide Convention. It must do so by meeting the heightened standard of fully conclusive evidence, that is, evidence beyond reasonable doubt. Where genocidal intent is to be established by circumstantial evidence, the conclusive evidence standard of proof is only met if genocidal intent is the only reasonable inference to be drawn from the facts in question. I thank the Court for its kind attention. Mr. President, may I ask you now to call on Ms. Cordone to present Myanmar's position on the method of proof. Thank you.
I thank Professor Talmon for his statement. I now invite Ms. Chiara Cordone to address the Court. You have the floor, Madam.
Mr. President, Madam Vice President, distinguished members of the Court, it is a distinct honour to appear here before you. Professor Talmon has addressed the burden and standard of proof, and it is my turn now to address the methods of proof. Let me start with the obvious. Not all evidence is to be given the same weight. Passage of time, hearsay, opinion rather than facts, all affect the weight that is to be given to evidence. The Gambia does not dispute these general principles of the law of evidence, but it disregards them in practice. For example, while it accepts that opinion evidence has no evidential weight, it repeatedly advances such evidence. While it does not dispute that hearsay cannot be conclusive evidence, it consistently relies on hearsay evidence. And while it does not dispute that media articles are not, quote, evidence capable of proving facts, unquote, it extensively references media articles in an attempt to bolster its otherwise weak evidence. These principles are not an end in themselves. Together with the best evidence rule, they ensure that the Court gives due weight only to those pieces of evidence which can safely be afforded such weight. Mr. President, let me move on from the general principles to particular types of evidence. The Gambia relies overwhelmingly on reports of the Independent International Fact-Finding Mission on Myanmar, the FFM, as well as reports of other official bodies and NGOs. According to the Gambia, these whole proceedings are essentially superfluous. The presentation, testing and evaluation of evidence, the hearing and cross-examination of witnesses are all a waste of time, because all the facts, including genocidal acts and genocidal intent, have already been established by the FFM. No need for the Court to go any further. Just adopt the findings of the FFM and these proceedings can conclude today. But the Court, however, cannot avoid its duties and absolve itself of its judicial responsibilities. It is for the Court to test the evidence, establish the facts to the requisite standard of proof, and then come to a verdict. There are no shortcuts here. It is for that reason that Myanmar calls on the Court to carefully assess and weigh the evidence put before it, especially the reports of the FFM, the IIMM, and the reports of other UN bodies and NGOs. Members of the Court, the Gambia tells you that you have relied on such reports before. But for what purpose? The Gambia does not say. Was it to establish a simple fact, such as the date of a meeting? or to establish genocidal acts and intent. Neither in the Bosnia nor the Croatia case did the court rely on such reports for evidence of specific acts of alleged genocide or of genocidal intent. The Gambia also does not tell you what evidentiary weight you attributed to such reports. Were the findings of fact in those reports simply noted, treated as credible, persuasive, or treated as conclusive, because it is conclusive that they must be in the present case. As with other methods of proof, the relevance and probative value of these reports must be considered on a case-by-case basis. The court has identified the key criteria which bear on the relevance and value of such reports. First, the source of the report. That is, whether it emanates from a single source or multiple sources, and whether the source is partisan or neutral. Second, the process by which the report has been generated. For example, whether it's based on anonymous sources or whether it's the product of a careful court or court-like process. Third, the quality or character of the report. That is, whether it contains statements against interest or statements of agreed and uncontested facts. Fourth, the first-hand nature of the report. That is, whether or not the body creating the report had access to the territory in which the events in question occurred. There is nothing inherent in the nature of a report produced by a UN body or an NGO that affords it weight as such. The court has scrutinized such reports like any other evidence and has stated that UN reports will be taken into account only, quote, to the extent that they are of probative value and are corroborated, if necessary, by other credible sources, unquote. For example, in the armed activities case, which you see on your screens, while finding that some UN documents contained convincing evidence, the court did not afford any weight to several reports, including one generated by the UN Secretary-General because of its reliance on second-hand reports. The court has never blindly accepted the conclusions of a report simply because it was prepared by a UN body, and it should not do so in this case. Where the court did give significant weight to a report by an official body, such as the Porter Commission in the armed activities case, the report had the following qualities. It contained evidence obtained by examinations of persons directly involved. Those persons were subsequently cross-examined by judges skilled in examination and experienced in assessing large amounts of factual information. The correctness of the evidence was not challenged by impartial persons for the correctness of what it contained. In addition, the credibility of the report containing the evidence was not challenged and, in fact, was accepted by both parties to the dispute. None of the evidence submitted by the Gambia meets these qualities, and none, especially the FFM and IIMM material, has been accepted by Myanmar. Contrary to what the Gambia contends, the court has not consistently relied on independent fact-finding reports. For example, in Ukraine versus Russia, which the Gambia referred to on Monday in support of its claims on this point, the court, in fact, after close examination, either did not rely at all on the documents and reports submitted by the applicant, or found them to be of limited or insufficient evidentiary value in proving the relevant facts or alleged violations. There is no evidence in the court's case law of wholehearted acceptance or even great reliance on such reports as claimed by the Gambia. reports and other evidence lacking the qualities identified earlier are not capable of being relied upon to any great extent, and certainly not to the extent necessary for establishing facts to the high standard of proof required in the present case. Finally, and importantly, where such reports purport to state a fact, but in reality rely on another document as probative of that fact, the court should look to the underlying document and evaluate its evidential weight. Thus, in the oil platforms case, the court examined satellite images underlying expert reports and found them insufficiently clear. Myanmar asks the court to apply the same scrutiny to the evidence in this case. The overlaying of a report cannot add evidential weight to the underlying document. Indeed, the overlaying report is a more remote source of that information than the underlying document, and as such should, as a matter of principle, have less evidential weight than the underlying evidence. To the extent that the overlaying report expresses opinions about the underlying document, it is mere opinion evidence, which is no evidence at all. For example, some reports of NGOs, such as Fortify Rights and Amnesty International, base their assertions on interviews with claimed eyewitnesses. However, a report written by an organization recounting what that organization has been told by persons interviewed by it is the definition of mere hearsay. There is no good reason why the court should have to content itself with second-hand hearsay descriptions in reports of the FFM and NGOs of what interviewees are said to have said to those organizations. The court should not give weight to such reports at all. Insofar as the Gambia seeks to rely on these reports as corroborating the existence of facts, it ignores that such reports, not being evidence themselves, can have corroborative value only if they are, quote, additional to other sources of evidence, unquote, proving those facts. Reports cannot be corroborated by other reports. Two items of unreliable evidence do not add up to reliable evidence. This is all the more so in cases where it cannot be known if the two reports are in fact based on the same information. For instance, if two reports are based on information given by the same interviewees. The court has said that it will, quote, treat with caution materials emanating from a single source, unquote. It must also treat materials with caution if there is no way of knowing if the materials emanate from a single source. Mr. President, members of the court, the Gambia also relies on witness statements. Here, the Gambia does not just disregard the principle of evidence, it distorts them. The Gambia argues that evidence submitted in accordance with the court rules is admissible, and for that reason, the court should accept evidence contained in, for example, unsigned statements. This confuses two questions. The question of whether unsigned witness statements are admissible in principle, and the question of whether any weight can be attributed to such statements. While the court may accept such statements, it must not accord them any weight. When assessing the evidential weight of unsigned witness statements, the court must take into account the form and circumstances in which the statements are being made. This calls for several observations. First, with regard to the form of such statements, the court has stated repeatedly that it, quote, cannot accord evidential weight, unquote, to statements which are not signed by the witness and give no indication that the witness is aware of its contents. This point is made on the very same page of the Croatia judgment relied upon by the Gambia to argue the contrary. The findings in the Croatia judgment clearly show that unsigned statements, while being admissible, cannot be accorded any evidential weight. In the face of this clear precedent, what does the Gambia do? It relies on a mere passing reference by the court to statements signed by those who took them to argue that the signature of interviewers or their organizations renders such statements reliable. But this ignores the main reason why the court did not give any evidential weight to statements not signed by the persons apparently making them. That is, that there is no evidence that the interviewees have ever even seen the contents of these statements. The court's rejection of interview records signed by police for the same reason logically extends to interview records signed by NGOs or other bodies. They cannot safely be afforded any weight. Second, with regard to the circumstances in which statements are made, anonymous statements do not allow the court to determine the circumstances in which they were made, and thus do not allow evaluation of the weight to be given to them. Therefore, no weight can be given to such anonymous statements. Where anonymous statements are prepared by multiple organizations, as in the present case, there is every possibility that the same person is giving statements to several different interviewers. Indeed, we know that different statements submitted by the Gambia, which appear to be multiple accounts, are in fact by one and the same person. The court, therefore, must not afford anonymous statements any weight. Such statements also cannot be used to corroborate each other or other non-probative evidence. But this is exactly what the Gambia asks the court to do, to treat multiple unsigned anonymous statements containing opinion and hearsay as mutually corroborative, despite each being inherently non-probative. The defects of these statements cannot be cured by quantity. The fact that there are several such statements does not add anything to their non-existent evidentiary weight. Even where statements are named and signed, the court must still scrutinize their evidential value diligently. In the oil platforms case, a Kuwaiti official's testimony was rejected because it was given a decade later and did not involve direct observation of the relevant facts, thus rendering it non-probative and unreliable. This kind of scrutiny must also apply in the present case. Mr. President, let me move on to evidence prepared for the purpose of the proceedings. The court must treat such evidence with great caution, especially where the witnesses have an interest in the outcome of the proceedings. The Gambia claims that interested witnesses can refer only to state officials from a party to the proceedings and does not apply to private persons. But this is not supported by the court's case law. In Nicaragua versus Colombia, the court noted that the 11 affidavits relied on by Colombia were prepared specifically for the purpose of the case and were signed by, quote, fishermen who may be considered as particularly interested in the outcome of these proceedings, factors that have a bearing on the weight and probative value of that evidence. The court consequently found these affidavits had no probative value. Mr. President, I now turn to two other pieces of alleged evidence offered by the Gambia: media articles and books. I can be quite brief here, because the court itself has held that these are not methods of proof, quote, capable of proving facts, unquote. Again, however, the Gambia seizes on the potential corroborative value of such media articles and books and attempts to use them to corroborate the existence of facts not proven by any other evidence. It therefore bears repeating that multiple documents not capable of proving facts, according to the court's jurisprudence, cannot add up to be capable of proving facts by way of corroboration. Mr. President, let me conclude. Questions of evidential weight lie at the heart of these proceedings, where a heightened standard of proof applies. The Gambia tries to downplay this by asserting that the same methods of proof apply in all cases before the court. While this is correct in principle, it ignores a basic logical inevitability. A higher standard of proof necessarily demands evidence of a higher quality, as the court has explicitly acknowledged in its Gambia tries to downplay this by asserting that the same methods of proof apply in all cases before the court. While this is correct in principle, it ignores a basic logical inevitability. A higher standard of proof necessarily demands evidence of a higher quality, as the court has explicitly acknowledged in its moral gravity. Those standards permit no dilution, neither by quantities of poor evidence incapable of proving facts, nor by the layering of reports and opinion upon defective material. The court is asked to judge the evidence for its substance, not its author or its presentation, and to have always firmly in mind the high standard of proof such accusations demand. I'm grateful for the court's kind attention. Mr. President, I'm in your hands as to whether you prefer a break now or after Dr. Staker, who I respectfully ask you to call next. He will speak for around 40 minutes.
I thank Mr. Cordon for her statement. I propose that we take a break after Mr. Staker. So I now give the floor to Mr. Christopher Staker. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, Ms. Cordoni has presented general principles regarding the evidential weight of different kinds of evidence. I now address the application of such principles more specifically to the Gambia's evidence in this case. There may be some repetition in my presentation of aspects of what Ms. Cordoni has said, but there is perhaps no harm in that in demonstrating how the general principles apply in the specific circumstances of this case. Little or no evidential weight can be given to any of the Gambia's evidence to prove the facts central to its claim of genocide, in particular its claims of widespread atrocities the facts central to its claim of genocide, in particular its claims of widespread atrocities committed during the operations of 2016 and Chapter 7 deals with that of the other evidence relied on by the Gambia. It's noteworthy that the Gambia's reply does not respond to many of Myanmar's points regarding evidential weight set out in its counter memorial, presumably because the Gambia had no response that would withstand scrutiny. But perhaps recognizing this gap in its case, the Gambia has said something about evidential weight in oral argument. However, as with so much of the Gambia's case, it is presented at a high level of generality and does not engage with the detail of the case. The evidential weight of a document must be assessed in relation to each fact for which it is relied on as evidence. A document may have evidential weight in respect of one fact, but not another. One cannot simply say that a particular document has evidential weight in the abstract and then treat every statement made in that document as a proven fact without any further analysis. I will begin with the evidential weight of the FFM reports. This is Chapter 6 in both of Myanmar's written pleadings. There's a whole chapter on FFM reports because the Gambia places such heavy reliance on them. They are the evidential centerpiece of the case. The application instituting proceedings says that FFM reports are especially significant, and over half of its footnotes refer to them. The Gambia's memorial contains extensive referencing to FFM reports. It systematically relies on conclusions and findings of the FFM as if this alone was sufficient to discharge its burden of proof to the requisite high standard. Its reply again references FFM reports extensively and describes other evidence as significant for the very reason that it corroborates the FFM reports. The Gambia has done the same again in oral argument. The FFM, they say, has a key role. Its findings are authoritative. Their case is fully underpinned by the FFM and what they call its thorough investigations. Over the last 4 days, you've heard the constant refrain of recourse to the FFM, its determinations, its findings, its conclusions. So more than 6 years after the introduction of this case, the centre of gravity of the Gambia's evidentiary file is the same as the one it had when it introduced the application. This is particularly telling as to the effort put in by the Gambia to ascertain the facts. The Gambia seeks to ridicule the argument that its evidential centrepiece has no evidential weight in relation to the matters for which it predominantly relies on it. But there are principled reasons why it does not. And before explaining why, let me give some background to the FFM, as well as to the other body, the Independent Investigative Mechanism for Myanmar, the IIMM. The FFM was one of many fact-finding missions and commissions of inquiry established by the Human Rights Council. The mandate of this one lasted some 2.5 years, from 2017 to 2019. It consisted of 3 members and had a core team of staff of about 15 people, none of whom appear to have had qualifications in forensic investigations or litigations. It conducted interviews of claimed eyewitnesses in the camps in Bangladesh and of certain others, collected documents, and produced its reports. Its report, on which the Gambia places the greatest reliance, was released only 1.5 years after the FFM was established. The late Professor Sharif Bassiouni, called by the International Bar Association a legendary figure in the field of international criminal law, said of bodies such as the FFM that a fact-finding mission, notwithstanding its name, is not necessarily a fact-finding mission. He said that such bodies have limited resources, that more frequently than not, the reports produced are designed to please the influential Geneva-based non-governmental organization community in certain governments, and that other states feel less influential in the process, and at times they even feel targeted by the process and the outcomes. In 2018, the Human Rights Council then established the second body, the IIMM, with the stated mandate to collect evidence for use in national and international judicial proceedings. The fact that this second body was given this express mandate indicates that materials produced by the FFM were not considered suitable for use in judicial proceedings. The FFM thereafter ceased to exist, and its records were handed over to the IIMM. The FFM reported that it interviewed many hundreds of witnesses, though not all spoke about Northern Rakhine State. Curiously, the IIMM has declined to share the FFM's records of the interviews that the FFM conducted with claimed eyewitnesses, even in redacted form. When asked by counsel for Myanmar to make these FFM interview records available, the IIMM said that it did not have permission to share them. Precisely whose permission has been withheld is unclear. So the intention was that in any judicial proceedings, it would be the work of the IIMM that would be used, rather than the work of the FFM, which was not suitable for such use. Yet even though the IIMM was supposed to continue and deepen the FFM's work, it only provided 42 witness statements to the parties in this case. It's unknown how many of the 42 people giving those witness statements were among the persons interviewed by the FFM back in 2017 and 2018. Thus, more than 7 years after the inception of its work, the IIMM could put forward only 42 potentially relevant witness statements. Of these, only 12 have been relied on by the Gambia in these proceedings. Can a finding of genocide be made on the basis of these 12 witness statements? In fact, a further 19 of the IIMM witness statements have been relied on by Myanmar in this case, on the basis that they're actually inconsistent with the Gambia's case. Can a case of genocide be decided on the basis of these 31 witness statements? Well, according to the Gambia, evidently not, because the Gambia still places central reliance on the FFM reports. Mr. President, members of the court, before proceeding, I must recall that Myanmar does not recognize the FFM or the IIMM and has not cooperated with the work of either. It was under no obligation to do so, and on behalf of Myanmar, I state here again what was already stated in Myanmar's written pleadings, that nothing said about either body in these proceedings implies any recognition of either of those bodies by Myanmar, or their mandates, or their work. Myanmar doesn't positively rely on the material produced by these bodies, or accept that it has evidential weight. Rather, Myanmar must refer to such material because it's relied on by the Gambia. Myanmar refers to it to explain why evidential weight cannot be given to it and why it does not assist the Gambia. Myanmar further maintains that in these adversarial proceedings, evidential weight should not be given to the product of a non-adversarial process in which evidence has not been challenged or tested, in which Myanmar was not required to participate, and in which it did not participate. and I explained earlier today why that is the case. Mr. President, members of the Court, the 2018 FFM detailed findings, the main FFM report on which the Gambia relies, says that the FFM conducted interviews with 875 persons, of whom at least 500 spoke about events in northern Rakhine State. Their report the following year, the 2019 FFM detailed findings, says that the FFM conducted a further 419 interviews, although it's not clear how many of these interviewees spoke of events during the operations of 2016 and 2017. Again, the FFM's interviewees are almost entirely anonymous, and not even the Gambia nor the court knows their identities. The FFM's conclusions of fact were based largely on these interviews with unidentified and unknown persons. We do not have all the FFM's records of these interviews because, as I said, the IIMM, which now has them, has not shared them. However, after the written pleadings closed in this case, the IIMM provided the parties with a new witness statement prepared by the IIMM, given by a person previously interviewed by the FFM. And this time, the IIMM also provided the FFM's interview note of this person. As a result, we now have one single example of a written record prepared by the FFM of an interview with a claimed eyewitness. And you will find this at tab 6.2 of your folder. What you will see is this. First of all, this document now confirms a guess made in Myanmar's written pleadings that the FFM did not take signed witness statements. The document you will see at tab 6.2 is not a witness statement. If you look at the last two pages, you will see that it is not signed by the interviewee. Nothing indicates that he read it or had it read back to him, or that he adopted it. Nothing indicates that he was told that what he said might be used in judicial proceedings. I will shortly refer to various statements in the note expressing doubts about the interviewee's credibility. The existence of these notes in the document suggests that this document was never intended to be seen by the interviewee. In Croatia, the court said unequivocally that it cannot accord evidential weight to those statements which are neither signed nor confirmed. Second, the wording of this interview note is that of the interviewer rather than of the interviewee. It says, for instance, the witness notes that, witness claims, witness made reference to, and so forth. You'll see that, for instance, on the first page in the first substantive paragraph, at the second page in the fourth paragraph and the second last paragraph, and on the third page at the second and the fifth paragraph. And in Croatia, the court said that it would not give weight to interview records when the wording appeared to be that of police officers, that is, the interviewer, rather than that of the witness. And for these reasons alone, according to the court's established case law, no evidential weight could be given to this document. And there's no reason to think that this document is atypical of all of the other interviews conducted by the FFM. There is no evidence that the FFM ever took formal signed witness statements, and it follows that no evidential weight could be given to any of the FFM's records of interview, even if all of the others were before the court, which they are not. And although I could stop there, there are also other reasons why no evidential weight could be given to the FFM interview notes. First, this interview note has not been produced with the care to be expected of a witness statement or affidavit used in judicial proceedings. It indicates that the interview was held on a single day, the 5th of March 2018. We see that on the first page, about halfway down, with the entry interview date. But although it gives the interview date, it doesn't indicate start and finish times of the interview, so the interview may have lasted for much less than a day. And that is likely because the staff of the FFM interviewed hundreds of witnesses in a short space of time. The part of this note setting out the substance of the interview takes up less than 3 pages. It lacks detail, and some of its language is telegraphic. For instance, on the 3rd page towards the bottom, you see that it says, post-25th plans, ? Likely to have future attacks if needed. This suggests that it was prepared under time pressure without attention to detail. The note does not make clear to what extent the interviewee claims to speak of matters of personal knowledge and to what extent hearsay or opinion or even just gossip. On the last page at the bottom, we see that the interview record itself was created on the 24th of April 2018, which was over a month and a half after the date of the interview itself, which was on the 5th of March 2018. It says it was modified on the 20th of August 2018, some 4 months later, but we do not know how it was modified, or by whom, or by why, or why. On the first page, against the heading Interviewer Name, we see that the anonymized FFM interviewer was a single person, apparently a staff member of the FFM, since the 3 members of the FFM were not in Bangladesh at the time. Now, although Myanmar does not accept that evidential weight can be given to IIMM witness statements, it is nonetheless instructive to compare this FFM interview note with the IIMM witness statement of the same person, which is found at tab 6.3 of your folder. You'll see at the bottom of page 2 and top of page 3 that the IIMM interview took place over 5.5 days, with precise start and finish times recorded for each day of the interview. You'll see in the footer of pages 2 and 3 that the entire statement is 46 pages long. And if you look at the whole of this document, and the whole of the document is in the case file, you'll see that the document as a whole makes clear that much of what this person says is hearsay or opinion. It also makes clear that this person was a member of ARSA and gives no indication that he ceased to be supportive of ARSA. And this is significant given the pervasive influence of ARSA in the camps in Bangladesh, where he appears still to have been living when this statement was given. And again, if you look at the full statement, you'll see that it even contains a statement that there is a high-level Shura group member of ARSA now responsible for all the Rohingya camps here in Bangladesh. Furthermore, this witness statement seeks to deny the massacre by ARSA of 105 Hindus in Kharmon Sheikh on the 25th of August 2017, an incident that even the Gambia has not disputed. This comparison between the FFM interview record at tab 6.2 of your folder and this IIMM witness statement at tab 6.3 makes all the more clear that the FFM document is not a document to which evidential weight could be given. And again, I repeat, nothing suggests that this FFM record is atypical of interviews conducted by the FFM generally. And there is also a further reason why this particular interview record lacks weight, namely that the FFM interviewer had doubts about the interviewee's credibility. In the document at tab 6.2, on the first page, at the top, you see that it said that the interviewee is an alleged ARSA member, and it says that he may have been evading questions regarding his ARSA-role relationship. On the second last page, just under halfway down the page, against the heading Reliability of the Source, we also see the interviewer's words, "It's at times difficult to tell whether witnesses like him are good or well rehearsed. I cannot discount that this witness may be well rehearsed." And on the last page, the interviewer's final note says that he was evasive about some matters. What is remarkable is that the main FFM report on which the Gambia relies refers to this very interview note some 22 times without giving any indication to the reader that there was any doubt about this person's credibility or reliability. The head of the IIMM himself recognises that the work product of the FFM was not suitable for use in judicial proceedings. He says, quote, "Given the limited time frame of its operations, the focus and methodology of the FFM was necessarily different in nature from that of the IIMM. Rather than having a mandate to issue public reports and make recommendations to member states, the IIMM's mandate is to collect, preserve, and analyse evidence so as to facilitate criminal prosecutions. Thus, the mandate of the FFM was not to collect evidence for use in judicial proceedings. Its very small staff, in any event, lacked the expertise to do so, having no one qualified in forensic investigations or litigation. Its interview notes are not, and were not intended to be, suitable for use as evidence in judicial proceedings, and certainly not for a hearing on the merits involving the high standard of proof applicable in this case. And for this reason, no evidential weight could be given to the FFM's written records of the interviews it conducted. So from there, I move on to the evidential weight of the FFM reports themselves. It's self-evident that the FFM reports are not primary documentation of any facts or contemporaneous records of events. They are not statements of any facts within the personal knowledge of the members of the FFM. They are secondary sources. They give second-hand summaries of events spoken of by those who the FFM interviewed, and second-hand descriptions of other documents that the FFM considered. The reports then contain the FFM's opinions and conclusions based on this material. Obviously, a secondary source has no greater evidential value than the original source. Being a secondary source, it will in fact have less value. Indeed, a secondary, tertiary, or quaternary source of information should be given no weight at all unless there are good reasons why it is impossible to produce the original source, or at least a document nearer to the original source. This is the best evidence rule. To the extent that the FFM reports set out the FFM's conclusions and opinions, they cannot be given any evidentiary weight. As the court has held, opinions are not evidence. The court must form its own conclusions and opinions based on the evidence. To the extent that the FFM reports are based on other publicly available documents, they can also be given no evidential weight. There's no reason why the other documents to which they refer could not themselves have been put before this court, in which case this court could examine them directly and form its own view of them. To the extent that the FFM reports are based on interviews with claimed eyewitnesses, they can again be given no evidential weight. For the reasons I've given, no weight can be given to the one FFM interview note that the parties have and which is now before the court. It follows that no weight can be given to the hundreds of others that we do not even have. And it follows that no evidential weight can be given to FFM reports giving second-hand descriptions of those documents to which no weight can be given. The FFM reports are in any event not even reliable descriptions of the interview notes. The FFM reports do not indicate when facts stated in an interview note were hearsay, or explain each interviewee's claim basis of knowledge for the facts for which their interview notes were cited, or note when the FFM had doubts about the credibility of an interviewee. There is in fact no indication that the FFM ever rejected the account of a single interviewee on the ground of lack of credibility. The FFM reports themselves just seem to accept the contents of interview notes at face value. To the extent that the FFM reports are based on other documents that are not publicly available, again, no evidential weight should be given to them in the absence of sufficient reasons why those other documents could not themselves have been produced. In short, this court cannot be told, you have no need to consider the evidence or make findings of fact, because the relevant facts have already been found by a United Nations body based on evidence that you have not seen. A court of law must make its own findings of primary facts based on the evidence presented to it, and must draw its own conclusions from the facts that it finds. Otherwise, it abdicates its core mission. And this is what the Gambia asks you to do in the present case, to abdicate your judicial function. And Myanmar stands by that word, Mr. President, members of the court, the Gambia seeks to avoid these difficulties by arguing that FFM reports should be treated like final trial judgments of the International Criminal Tribunal for the former Yugoslavia, the ICJ. In both Bosnia and Croatia, the court said that it should in principle accept findings of fact in trial judgments of the ICTY as highly persuasive, and that it should give due weight to any evaluation by the tribunal based on the facts, such as about the existence of a genocidal intent. However, no possible valid comparison whatsoever can be drawn between ICTY judgments and FFM reports. First, in both Bosnia and Croatia, the parties agreed that the court should give such evidential weight to ICTY judgments. That is not the case here in relation to the FFM reports. Second, the court did not suggest in Bosnia and Croatia that it would accept findings of the ICTY unquestioningly. It made clear that it still must itself make its own determination of the facts. And third, the ICTY and FFM were entities of an entirely different nature. The ICTY was a judicial body created by a Chapter 7 resolution of the Security Council with binding authority to require states to cooperate with it. It had an adversarial judicial procedure complying with the International Covenant on Civil and Political Rights. It applied a standard of proof of beyond reasonable doubt comparable to that applicable in this case. The accused were presumed innocent and had the right to counsel, to cross-examine witnesses, to call witnesses of their own, and the right to pre-trial disclosure of the evidence against them. Parties also had a right of appeal, and even after final appeal, proceedings could be reopened if new facts were discovered. Its judgments were given by professional judges elected by the General Assembly, who personally, individually, sat through the whole trial and personally heard all of the witness testimony and all of the challenges to it. Its proceedings were generally in public and followed published rules with the possibility of procedural challenges. In contrast, the FFM was of a non-judicial character. It had no published procedures. Its proceedings were not adversarial. There was no adversarial scrutiny of the evidence and no procedure for challenging its reports. It applied a low reasonable ground standard of proof. Claimed eyewitnesses were apparently interviewed by unidentified staff of the FFM rather than by all or one of its 3 members. This means that eyewitness accounts in FFM reports are at least double hearsay. They state what FFM members were told by an FFM staff member about what the staff member was told by interviewees. There is also no comparison between the ICTY and the FFM in terms of resources. At the time of the court's judgments in Bosnia and Croatia, the mandate of the ICTY had already lasted 14 and 22 years respectively, and it had hundreds of full-time professional staff, including qualified and experienced forensic investigators and litigators. Also, full records of proceedings before the ICTY, including video recordings and written transcripts, were kept and are for the most part publicly accessible. Unlike in the case of the FFM, it is generally possible to look at the actual evidence on which the ICTY based its findings and its judgments and assess the reasons for it accepting or rejecting that evidence. Most importantly, the court was unequivocal in Bosnia that it would give weight only to final trial judgments of the ICTY and not to other decisions, such as decisions of the prosecutor to include charges in an indictment, or decisions of a judge or chamber to confirm an indictment or to issue a warrant of arrest. The court said clearly that claims made by the prosecutor in the indictments are just that, allegations made by one party, and that as a general proposition, the inclusion of charges in an indictment cannot be given weight. The FFM expressly applied a standard of proof of whether a competent prosecutorial body would have sufficient elements to prepare a case for adjudication. This does not purport to be anything more than a decision of a prosecutor to bring certain charges. In fact, it's obviously something less than that. And it follows from Bosnia that the FFM reports have at their highest the status of allegations which cannot be given weight. Mr. President, members of the court, the Gambia also tries to draw analogies between the FFM reports and a report of the Secretary General called The Fall of Srebrenica, which was one of the items of evidence relied on by the applicant in the Bosnia case. The court said in Bosnia that it gained substantial assistance from this report of the Secretary General. However, the court in no way suggested that the entire contents of this report could be treated like a final trial judgment of the ICTY. In Bosnia, the court relied on this report in relation to certain specific matters in which the United Nations itself was involved at the material time and which were recorded in contemporaneous documents in the United Nations archives on the basis of which the report was prepared. The court did not specifically rely on this report as evidence of any of the facts relating to the particular acts alleged to be genocide. The FFM reports were not prepared by the Secretary General and do not relate to matters within the institutional knowledge or archives of the United Nations or the Human Rights Council. It's not clear what analogy the Gambia seeks to draw between the FFM reports and the fall of Srebrenica, or how it's said to assist the Gambia. Mr. President, members of the court, for these reasons, no evidential weight can be given to the FFM reports, and it is in fact surprising that the Gambia relies on them. The United Nations, at very considerable expense, at the time of a liquidity crisis, has now established the IIMM with the express mandate of collecting and producing witness statements and other evidence for connection in use with judicial proceedings. And despite this, the Gambia clings on to the FFM reports as its primary evidence in the case. Some 42 witness statements taken by the IIMM have now been provided by it to the parties in this case, but the Gambia has relied on only 12 of them. Myanmar itself has produced 19 others, many more than even the Gambia itself. The Gambia continues to base its case on the FFM material to which no evidential weight can be attached because there is no better evidence that supports its claim of genocide. The Gambia seeks to deflect this criticism, saying that it does not know what Myanmar is talking about. But the point is obvious. The IIMM analytical reports do not deal with the core events of 2016 and 2017, and there are, in any event, very few references in the Gambia's written pleadings to these IIMM reports. As to the IIMM witness statement, it's a plain fact that the Gambia has relied on only 12 out of the 42 made available to it. It's a simple fact that it places limited reliance on IIMM material and makes the FFM reports the heart of its case, despite the fact that the FFM was not created for the purpose of producing evidence for use in judicial proceedings, while the IIMM purportedly was. The Gambia must acknowledge this simple truth. It has no better evidence than the FFM reports. Mr. President, members of the Court, that concludes my presentation of Chapter 6 of Myanmar's written pleadings. I thank you for your careful attention. Mr. President, could I please invite you now to call on Ms. Laurie, who will address the background facts about ARSA.
I thank Mr. Staker. Before I give the floor to the next speaker, the court will observe a break of 15 minutes. The sitting is suspended.
Yeah, Kuro Jojokra Sahata Devo, 15 minutes Bade Avaraibo. 15 minutes Bade Begina Varhuneveribo. Bar Sarba out of Bahar or Parot. Sayana, Tayanaraba and the Jurita giver.